Hello everyone, my name is Brandan Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. In this video, I'm going to talk a little bit about DUI and what it is and what it means. Now, most people have a general idea of what DUI is. They think that if I'm pulled over on the side of the road and I take a breath test and I blow over a .08, then I'm going to get charged with a DUI. If a person sits down and reads the state statute on DUI, there's only a very brief part in the statute that discusses the .08 legal limit. Now that isn't exactly what the state has to prove. What a state has to prove, or a city has to prove when they charge somebody with a DUI and are seeking conviction, is that the person operated a vehicle or attempted to operate a vehicle, and that they did so while they were impaired to a level that they were unsafe to operate the vehicle. Now there's a couple of different ways that the state can do that. The first way is to say the person was impaired by alcohol and drugs, or some sort of combination of the both. Those people are generally going to go through a blood test or some sort of field sobriety test conducted by a DRE. Those are probably the least common DUIs. A second way a state can try to prove that you've committed a DUI is through trying to prove that you're over the legal limit. There's an arbitrary line. If someone has a blood alcohol level of over .08, then the presumption is that they're impaired to a level that they're unsafe to operate. Now the state still has to prove that you're operating, and they still have to be able to get that evidence in against you that you were over the .08, but that's probably the most common way that they will try to prosecute somebody for a DUI. The third way is what they call a totality of the circumstances DUI. Now, a totality of the circumstances DUI is essentially when someone refuses a breath test or for whatever reason they don't have a breath test. In that instance, the state is going to say, well, look, judge, or look, fact finder, we don't have any scientific evidence this person was over the legal limit, but we have a variety of different pieces of evidence that we think, if you add them all together, can prove that a person was impaired to a level that they were unsafe to drive. Those type of pieces of evidence would be the admission of alcohol consumption, the odor of alcohol consumption, the performance on what they call pre-exit tests, the performance on field sobriety tests, and any other type of evidence that the state wants to present that they believe that will help a judge or a fact finder determine that a person was impaired to a level they're unsafe to operate. Now, as you can see, DUI is a very complicated area of the law. If you have questions about a DUI charge, you've received a DUI charge and you need help, feel free to contact my office. Thank you.